normally all the information you feel like the board may re-interlace all these exhibits in this case?
Well, I would request that the exhibits that I presented tonight all be entered into the record.
In the record?
Yes.
Maybe one mark, sorry, just for clarification purposes. Would we mark the application as 12 and the
Yes.
emails as 13?
That would be great, thank you.
Are there any objections to these documents? No objections?
Anybody on the board have any questions for Mr. Omatick?
No.
I have one, and I think it's a big one. I want to know why you consider the property non-conforming. Number one, if the trailer park is zoned R4, and the other section is zoned R1, they're both in compliance. Where's the non-conformity side?
It was non-conforming before it was done. The trailers were there before the zoning. That's what a non-conforming use is. And he's allowed to continue it by a matter of law. It's a vested property right. And that interest runs with the owner.
And is
That's something the zoning board needs to understand, and your solicitor will explain that to you. All the evidence that the township solicitor entered is irrelevant to your determination. Your determination is, were the trailers there before the zoning, and is that how that parcel of land is used, and is that how that parcel of land is still being used? That is a continuation of a non-conforming use.
it was conforming, sir, when the trailer was up on the hill before the landslide. Then the landslide occurred. Now it's non-conforming because it's down, you have two residences in an R1 now.
The only thing that made it non-conforming was the enactment of the zoning ordinance and establishing that as R4. It was made a trailer park after the trailers were there. The use of it as a trailer park predated the zoning. So it was non-conforming when the zoning went in. It's allowed to continue that way, and that's a right that Mr. Omatick has in the property that runs with the land.
Respectfully, sorry, louder again. Respectfully, the trailer park in the R4 is conforming, and it can continue with the land because it's conforming then, it's conforming now. The creation of the R1 and R4 basically created a parcel of R1 where his home could be. There's never been a second occupied structure in the R1. And your zoning ordinance doesn't allow for it. It allows for the zoning park exactly where it is situated.
Yeah, maybe that's my question. Maybe that's the point of this case. So is it your position, since the parcel existed prior to the zoning and that there were trailer homes on the entire parcel prior to the zoning, that he is able to move the trailer homes anywhere on that parcel even after zoning is established?
Yes, that's exactly right. And not only that, he can add trailer homes. You can actually.
So he can do whatever he wants in that
No,
R1
he can
district
do
as
whatever he
long as
wants.
it's a trailer park.
He can do whatever he wants. There's certain things he's allowed to do. There's the doctrine of natural expansion. He could add trailer homes to that parcel of property because he has a pre-existing non-conforming use. And the law and the courts have said that you are allowed to continue that pre-existing non-conforming use. It's always been used that way, and he can continue to use it that way.
Were there ever more than one residential structures in the R1 parcel? No. That didn't.
But the property is one singular 42-acre parcel.
I get that it's one tax parcel.
The zoning does not divide it up into separate parcels. It's one parcel.
Certainly, you're not arguing there's no such thing as splits in the law.
No, you can have split zoning, but if you have a a non-conforming use that predates that, the person's entitled to continue that non-conforming use.
The continuation of that use is applicable to the area where the trailer parks are located. It doesn't somehow expand into the area that has been zoned R1 since there's been zoning, and I haven't heard any evidence for him to demonstrate exactly which zoning ordinance was in effect at the time those trails were in there, but it is irrelevant because as it exists to that section, yes, that use can continue. Even if it was there before any zoning, the zoning essentially blessed a trailer park in that particular area. You can't then cross over and expand to the other split parcel and apply some non-conforming use extension to the split parcel section that is specifically R1 and only allows for one use on that property, one occupied structure. There's nothing magical about the where and when the mobile home park was related to the split zoning. There's nothing magical that makes it then allow in the R1 district him to do whatever had been existing in a different portion of his parcel beforehand.
So procedurally, there's been direct questioning, cross-questioning, question from the board. Are there any other questions?
Anybody from the audience have anything for Mr. Omatick? No? Ms. Moore, do you have another witness you want to call?
Yes.
Wait, I have another witness.
Oh, I'm sorry.
That's all right. I'll just have the zoning officer testify.
Do you want me to re-swear everybody or just have them continue because she testified last month?
No, that's good, she's sworn.
Okay.
Ms. Ross, were the trailers there on that property before it was zoned R4?
I believe so.
Okay, that's all the board needs to know, really. I don't have any other questions for Ms. Ross.
I have nothing for Ms. Ross. Anybody?
No.
Continue.
Okay, are you done with your witnesses?
I don't have any other witnesses.
Okay. I have a couple witnesses to call. I'll start with Ms. Ross since we're right there. Okay. Ms. Ross, you're the zoning officer for Cecil.
Yes, ma'am.
And how long have you served in that capacity?
Well, officially, the beginning of this year, I was appointed as acting zoning officer in April of last year.
And you received the application for a zoning permit on August 8th, 2019, the one we referred to earlier?
Yes.
Okay. And that was for a storage shed building unoccupied, correct?
Yes.
And did you clarify that with the applicant?
Yes, ma'am.
Okay. And in fact, as we already saw in Exhibit 5, we saw your initial letter that you preemptively sent to the applicant. So just let him know, hey, I understand you've applied for a storage shed, which is fine, but if you want to occupy that structure, you would need to subdivide the property.
Correct.
Okay. And you did that on August 21st, 2019, right after he applied for his zoning permit, correct?
Yes.
Do you have a copy of that exhibit in front of you?
What number is it?
Do you have the book?
Yes.
Yeah, it'd be number 6.
Yes.
Okay. And you explained the split parcel zoning. And you explained that you can have only one building for residential purposes on the R1, right?
Yes, ma'am.
Okay. And then on May 12th, 2020, that was Exhibit 7. That's when you issued your notice of violation, correct?
Correct.
And in fact, on the second page of your letter, you explained to Mr. Omatick that he can have the second occupied structure on that parcel if he subdivided. Do you see that? The first full paragraph on the second page of your letter.
I do.
Okay. And is that the only instruction you've ever given Mr. Omatick related to how to make this particular move compliant?
Yes.
And you spoke spoke back and forth with Ms. Mallory as well, correct?
Yes.
Okay, I'll introduce that email with you. Did I give you a copy of this one?
I think I have copies. Yes.
This is the email I started to present with Mr. Omatick, but we didn't present it. So did you have conversations with Ms. Mallory about the storage shed at the time?
Yes.
Okay. And you also had email communications, correct?
Yes.
And was one of your concerns the purpose for which the mobile home was going to be utilized when you were issuing the zoning permit?
Yes.
Okay. And did you ask her specifically what it was going to be utilized for?
Yeah, I don't know that I actually asked. I just explained, should it be used as a residence and should it be used as storage?
Okay, so you explained to her that for storage it was okay, and that if it were going to be used as an occupied structure, you would need to subdivide.
Right.
Okay, and is that set forth in your email dated August 5, 2019?
Yes.
Okay. And that would be on the second page of Ms. Ross's email. And that particular advice states on the second page, second full paragraph, should the decision be made that the modular home will continue to serve as a single-family dwelling and move it out of the R4 zoning district and into the R1, application should be made to subdivide the property, as there is already an existing single-family dwelling located on a portion of the property zoned R1, correct?
Correct.
Okay, and Ms. Mallory wrote back to you on August 7, 2019, and that email is before the email we just looked at, on the top of the page. And what did Ms. Mallory tell you?
She says he will be using this space for storage and it will be located amongst all of his other storage buildings and barn.
And you relied on that information, right?
Yes.
You heard that information both from Mr. Omatick and Ms. Mallory, correct?
Correct.
When did this particular structure first appear on the R1 portion of this parcel? Approximately.
I want to say fall of 2019. I believe it was when it was moved onto the R1 portion.
Okay. It didn't exist in that particular place before the fall of 2019.
Correct.
And I don't think I need to belabor all of your letters. They're in there, they're in evidence, and we went through the timeline with Mr. Omatick about the letters you sent to him, the notices of violation, and the notices of violation related to construction.
Yes.
And after you issued the notice of violation related to construction, did that construction cease?
Yes.
Okay, thank you. That's all the questions I have for Ms. Ross.
Anybody have questions from Ms. Ross?
No.
No. Anyone in the audience? Chris? Is there anything further?
I do. I'd like to call Mr. Harold Ivory, please.